Have you ever seen your work being used by somebody else and you wonder what right you have? How do you go about enforcing that right, if any? Welcome to L'Education, our weekly legal podcast where we break down legal issues, legal topics, legal concepts, questions that you have to your understanding in a way that you won't need to go to the law school. All right, today we are going to now narrow down our discussion to one aspect of intellectual property that we started last week. Today, we are going to circle down on copyright in Nigeria. I am sure you have heard that word before. You have probably used that word before. And if I ask you, what is copyright? Well, somebody may say the right to copy. Maybe the right to copy somebody else's work or anything. Well, just stay with us. We are going to break it down. Copyright is that right that the law gives to a creator of a work to have exclusive rights to use, reproduce, distribute his works, and to prevent any other person from using that work without his permission. Under the Nigerian law, there are various categories of works that are protected under the copyright. Number one is literary works. Literary works having to do with books, softwares, anything written. Number two, artistic works. Any form of artistic work. You are a painter, you make creative artistic works and all of that. Musical works are protected under copyright. You go to the studio to record or you do a song that is original to you. Yes, it is protected under copyright. You also have sound recordings. This time around, it doesn't have to be music as we know it. It can be a sound that you produce, maybe as a musician, you produce a soundtrack, whatever it is. Sound recording generally is protected also by copyright. Broadcasts are also protected by copyright. Also, cinematograph films. Cinematograph film, that could also include photographs and all. Now, we are going to, break all of this down, maybe discuss them one after the other in our subsequent videos. You hold copyright in a work if you can prove originality, that is, that work originated from you, or that you are the one who first did that work. Or if not you directly that did the work, but you have expended some level of creativity in a work that it has now become unique to you. That's originality. You will be able to prove that you own copyright in that work. That means that if I stay in the studio, record a song that belongs to somebody else, and then somebody else uses my recording, I will not be able to hold that person accountable or anything because the work is not originally my own. All right, it's somebody who has originality or who expended a level of creativity in a work that it has also now become his own. That's the person that can prove that he owns copyright in that work. Number two is that it must be in a tangible medium of expression. And what does that mean? You may have 1 million songs. You may have 1 million songs in your head, but you have not expressed it in a tangible means. Maybe by going to the studio to record it, and you have the soft copy on your maybe system, or you have expressed it in a CD or whatever. Or you have many books in your head, but you have not written them down, whether by typing or even your handwriting, no matter how bad your handwriting is. As long as you have expressed it, it is no longer an idea, it has been expressed. Your idea has been transmitted into a tangible means, or it has been expressed in a tangible way. You can claim copyright in that work. All right. On this issue of tangible medium of expression, I like to make it clear that it does not matter how sophisticated the medium of expression is. No, it does not matter. Even a jot, you take a jotter and you scribble something on it, you own copyright on that thing. No matter how rough you think it is, you have expressed that idea even in a sheet of paper. You have recorded a song. No matter how much people think that song is not melodious, as long as you have recorded it somewhere, maybe it has not even been released to the public, you have not even put it on any platform, but you have recorded it, it's already on your phone, it's already in a soft copy whatever it is, all that is required is that it is no longer an idea. It has been expressed. The law does not state what particular means of expression it must be, only that it must be a tangible, something that can be seen, something that somebody can relate with. A lot of you may even have copyright on a lot of things that you do not even know about. A lot of things that you own copyright on and you have taken for granted all this while. But I'm sure after this video, you have a change of heart or to understand better your right. In terms of registration, what do you need to do to protect your copyright?